Good afternoon, folks. I'm Luke Swetland, President and CEO of the Museum and the Sea Center, and I'm delighted to welcome you all to this, our second Lunch and Learn webinar of 2026, presented by the museum's Planned Giving Advisory Council. You know, for over a century, the museum has been committed to providing education in many forms to this community, and much of it we offer at no cost, like today's program, which is designed to help us understand how to think about estate planning when you're in a blended family. So there's a lot more dynamics that have to be sorted through. And for most people, an estate gift is very likely the most impactful gift they will make in their lifetime. So, yes, of course, I hope you will consider the museum in your estate, but just make sure you're taking care of all the many people that are involved in your life. So what's going on at the museum? We've received several shipments of butterfly chrysalids from Costa Rica. They're emerging in our emergence chamber, and we're releasing them into the Sprague Pavilion for the opening of Butterflies Alive, May 23rd. As a companion to Butterflies Alive, we have a fabulous exhibition in our Maximus Gallery about Lepidoptera and folks that who have collected moths and butterflies and done amazing natural history art about them. So kind of two great things to experience. June 27th is our annual wine festival, and it will be a sellout again. So get your tickets now. Enjoy dozens and dozens of premier wine and great small bites from regional caterers and restaurants on June 27th. We're also starting a project now over the next year and a half to reimagine our marine, paleontology, and Gould halls. We're going to upgrade the visitor amenities, refurbish the exhibits, bring in some new specimens and new experiences, and those halls will be reopened in early 2028. So they won't close until the end of this year, but then they will be closed for a little bit over a year. So be sure and come and visit the museum. There's a lot to see and a lot to do. But let's get to today's program. And for that, I'll turn this over to my colleague, Andrea McFarling. Andrea?
Thanks, Luke. Hi, I'm Andrea McFarling, Santa Barbara Museum of Natural History's Philanthropy Officer of Legacy Giving. We're happy to share with you this free webinar with helpful information on some of the common pitfalls and proven strategies to protect loved ones in second marriages and blended family situations. Today's webinar is presented by our good friend Christine Roberts. Time has been allotted at the end for questions. Please place your questions in the chat, which you should see at the bottom of your screen. If you should have any technical issues today, please email Robert Shutt. His email has also been placed in the chat. Feel free to reach out to me if you have any planned giving questions or need more information. I'm here to help you leave your legacy, and hopefully you will keep the museum in mind in your planning. Now I'd like to introduce to you our speaker, Christine Roberts. Christine is a partner and a member of the Planned Giving Group at Mullen and Henzell, L.L.P. Chris brings expertise in the area of retirement plans and IRA accounts and is designing estate plans that work harmoniously with the transfer of these assets from one generation to another. She strives to provide practical advice to clients in language that they can understand and act on with assurance. Christine has been active in a number of nonprofit groups in the community since moving to Santa Barbara in 1994, including Habitat for Humanity of Southern Santa Barbara County and Friends of Los Baños del Mar. In the past, she's also served successive terms on the library board for the city of Santa Barbara. Please join me in welcoming Christine. And Christine, thank you so much for speaking with us today. I turn it over to you.
Thank you, Andrea. I'm very pleased to be here and to hopefully present some useful information to you. So next slide, please. We'll start with an overview of where we're going to go today. There's just a few high points we're going to try to cover. The first is the need for a tailored estate plan, and I'll talk in more detail about what I mean by a tailored estate plan. We'll talk about what a blended family really means. It can mean a number of different things. We'll talk briefly about attorney ethics in representing blended families. We'll talk about one of the key concerns with a blended family, which is providing for a surviving spouse and for children from prior marriages. We'll talk about prenups and postnups, and we'll end with a discussion of retirement accounts and life insurance, mainly because a lot of our talk will be about trusts, and retirement accounts and life insurance benefits pass by beneficiary designation, not generally through a trust. So there needs to be harmony between the retirement accounts and life insurance and the trusts. Next slide, please. So how about the need for a tailored estate plan? Well, a tailored estate plan is I'm an estate planning attorney. I'm always going to recommend one, but not in every single instance. But generally, the benefit of a tailored estate plan, one that involves a revocable trust, a pour-over will, durable powers of attorney, advanced healthcare directives, is that it avoids probate, which is a lengthy and expensive public process of settling a decedent's estate. It allows you control over your estate, whereas if you don't have a tailored estate plan, the probate code will say who gets your property at your death, and it can minimize taxes. The need for a tailored estate plan is enhanced when you have beneficiaries who may have competing interests, or when a surviving spouse could disinherit one or more beneficiaries, maybe children from a marriage prior to the marriage with the surviving spouse. Next slide. And so the need for a tailored estate plan is enhanced when you have a blended family. What is a blended family? One obvious definition is couples with adult children from different relationships or marriages, couples who have joint children and children from different relationships, couples with minor children from different relationships, couples in an original marriage who want their portion of the estate to go to different beneficiaries. So you could have an original marriage, no divorce, no remarriage, no second spouses, but each husband and wife want their share of the estate to go to different people. So you have competing groups of beneficiaries. So blended family, everyone thinks of the Brady Bunch, and that is a blended family where you have two people marrying with children from prior marriages. But it could also be, like I said, an original marriage with a desire to have different beneficiaries at either death. Next slide, please. Next slide, please. Sorry, attorney ethics. One of the things that can happen with a blended family is a surviving spouse may be put in a position through lack of careful estate planning in advance of someone's death. The surviving spouse could be put in a position to disinherit beneficiaries, either their own children or children of the deceased spouse's prior marriage. This could happen when everything in the estate, in a married couple's estate, pours into the survivor's trust for their surviving spouse. If everything is in the surviving spouse's trust, and the surviving spouse has the ability to change the beneficiaries of that trust, then children from the prior marriage of the first spouse to die could get cut out. What happens when you are the surviving spouse and you want to disinherit your deceased spouse's children? Will the attorney you go to see take on that kind of work? And some attorneys, many attorneys, will refuse to take on this type of work because it will really very likely lead to litigation, and they will be called to testify, and it will be a bit of a mess. So not only is it not ideal that an estate plan is left in a position for a surviving spouse to disinherit children of a first marriage, it could be difficult to get legal representation to do that. The better approach is to have an estate plan that prevents this from happening. The basic technique, it's not super complicated, but the basic technique is an estate plan design that locks in some portion of the estate of the first spouse to die for the benefit of the first spouse to die's chosen beneficiaries, who may be, not always, but may be the children of a first marriage. So again, without advanced estate planning, everything could pour to a survivor's trust, be left to the whims of the surviving spouse. The surviving spouse could get remarried and leave everything to a new spouse, could join a cult that convinces them to give over all their material wealth, could have new children. A lot of things could happen in the surviving spouse's life. And if everything goes to their control, the ability to coordinate the needs of different groups of beneficiaries is eroded, and lawsuits, unhappiness, disappointment can result, and some ethical issues can be raised for attorneys presented with the request to disinherit people, people who meant something to the first spouse to die. Next slide, please. So I've already queued this up and said that the secret strategy here, or not so secret strategy, is to create what lawyers call an irrevocable trust that arises on the death of the first spouse. What is an irrevocable trust? An irrevocable trust is a trust that when it arises on the death of the first spouse to die, it cannot be changed or modified or terminated by the surviving spouse. Again, it cannot be modified or terminated by the surviving spouse. Very often, these irrevocable trusts will have as their trust property the first spouse to die's separate property and their half of the community property. And that share of the estate will pass to the chosen beneficiaries of the first spouse to die, without the surviving spouse being able to reroute or terminate that trust. Now, it doesn't leave the surviving spouse out in the cold altogether. The surviving spouse can benefit from the income of that irrevocable trust and from the principal, the actual trust property. But their access to the trust property, the principal, is generally limited to the needs for their health, education, maintenance, and support. They cannot have it for a whim. They cannot have it to give away. They cannot have it to buy fur coats and Lamborghinis. They can have it for medical care, for housing, for their basic subsistence. So again, if an irrevocable trust is created that arises at the death of the first spouse to die, the surviving spouse can benefit under it, but they can't substantially erode it, terminate it, or reroute it to new beneficiaries. So that's one of the key planning tools for a blended family, an irrevocable trust that arises on the death of the first spouse, that provides for the surviving spouse, but doesn't let the surviving spouse evaporate or reroute those trust assets. Another way to provide for a blended family is estate planning provisions for tangible personal property, your belongings, who gets what. Most of our estate plans at Mullen and Henzell provide that there will be a list or letter in writing that lists the important belongings, the artwork, the jewelry, the toolbox, the meaningful things, on one column, and who gets them on the next column. And so you want to think about your important, meaningful family heirlooms and belongings and who you want them to go to, because in the absence of that list or letter, the surviving spouse will probably be able to dispose of all of those belongings to whomever they choose. And especially if you have meaningful things from your relationship with the kids of a first marriage, you want to make sure that you provide that list or letter so that those meaningful paintings or jewelry or toolboxes or artifacts go to the people you mean for them to go to. And then there's provisions for the family home. Usually the surviving spouse has what we call a life estate, an ability to reside in the family home for their life, but the family home reverts to remainder beneficiaries at the surviving spouse's death. That isn't always the case. Sometimes the surviving spouse is given the ability to inherit the family home. Sometimes they can sell it, but the proceeds of the sale have to remain in trust for the remainder beneficiaries. And again, the remainder beneficiaries are those who take after the surviving spouse, and those could be the children of the first spouse to die's first marriage. So to recap, the main planning tool for a blended family is an irrevocable trust that arises on the death of the first spouse, that the surviving spouse cannot change or invade, that they can benefit from, but only for health, education, maintenance, and support. Um, Provisions for tangible personal property, meaningful belongings, and provisions for the family home that give the surviving spouse the ability to remain in a home for their lifetime, but with the sale proceeds of the home or the home itself reverting to the remainder beneficiaries, who may be the children of the first marriage of the first spouse to die. Next slide. So what about prenups and postnups? Well, you do see them with blended families, not necessarily more often than you see them with original marriages, but you do see them in some factual settings that we'll discuss. They're a good idea if there is a significant wealth disparity between the spouses. One spouse has significantly more assets and income than the other spouse. You do see them when there's significant separate property on both sides, and there's a desire to preserve the separateness of that separate property being property that you already owned before you came to marriage. You can see them when one spouse inherits a lot of money during a marriage. There could be a postnup that says that that inheritance remains a separate property of that spouse who inherited it. And even a lot of people say, well, I don't need a prenup or a postnup because I don't have anything. I just have debt. And my response as an attorney to that statement is you need one, especially if you have debt, because in a community property state, if you have a separate property debt that you repay with community assets and that marriage ends, there could be a recoupment claim for the community property, half of the community property that went to pay that debt. So you could end up paying off your debt and paying off your ex-spouse. So debt is not a reason not to have a prenup or a postnup. It may be a reason to have a prenup or a postnup. If you do have a prenup and you go to do estate planning with a spouse, or if you go to do estate planning or revise estate planning and you've entered into a postnuptial agreement, your estate planning attorney needs to review it to see how it impacts your estate planning design options. Very often, prenuptial and postnuptial agreements dictate estate planning provisions, how the spouse will be provided for in the estate plan, usually of the spouse with more assets. But sometimes it's mutual agreements about how they each will treat the other in their respective estate plans. And there can be some pretty detailed provisions in those prenuptial agreements. And as an estate planning attorney, surprised sometimes by the degree of specificity about estate planning provisions that are put into these agreements. So it is very important if you do estate planning and you have an existing prenup or postnup, that your estate planning attorney be well aware of that agreement and have the opportunity to review it. And, one question a lot of people ask is who should do a prenup or a postnup? Should it be an estate planning attorney or a family law attorney? And our firm very often refers clients to family law counsel for a prenuptial agreement. But feedback and input from estate planning counsel is sometimes advisable, mainly because a marriage can end two different ways. It can end in divorce, in which case the input of the family law counsel is crucially important, and it can end in death, in which case the input of an estate planning attorney could be important. And generally, the estate planning, I'm sorry, the prenups and postnups we see that are drafted by family law counsel obviously anticipate the end of the marriage by death and have provisions for that. And that's where some of those estate planning rules and requirements are relevant. So family law counsel seems to be best practices, but it is a case-by-case decision as to who the best type of counsel is to prepare these documents for each couple seeking them. Next slide, please. Retirement accounts and life insurance, as I mentioned, do not pass in a family's revocable trust. They pass by the beneficiary designation that is provided by the insurance company or the retirement account custodian or trustee. And so how you fill those forms out and how you maintain those forms as your life changes and as marriages end and begin is very important. And as someone who spent a good bit of their career as a retirement plan attorney, I was shocked and surprised by the frequency with which I found that people had gotten divorced but not changed their beneficiary designation for sizable IRA accounts. People had sizable IRA accounts and had not filled out a beneficiary designation. And when that happens, the default can be it can be a surviving spouse, it can be children, it can be an estate, but it's a little bit of a guess. Every custodian's agreement, every IRA vendor custodian agreement may be different. So not having a beneficiary designation, not updating a beneficiary designation is one of the most prevalent footfalls I see in the estate planning arena, and it's very easy to avoid if you just are on top of where your account information is. Usually it will point you as to how to update your beneficiary designation. So beneficiary designations for what we call contract assets, retirement accounts and life insurance, because they're contracts that pass by beneficiary designation. The designations in your contract assets may not be consistent with your estate plan, and you need to review them whenever you are preparing or updating your estate plan. A lot of times people update their estate plan because a marriage has ended or begun, because children have arrived, or children have reached the age of majority, or children have their own children. So these big family transitions and keystone events are a really good juncture at which to revisit your beneficiary designations for your IRAs and your life insurance policies. Now, one potential strategy for a blended family is to leave a retirement account to a new surviving spouse, a second spouse, or a subsequent marriage spouse, but to contractually require the surviving spouse to name as beneficiaries, so successor beneficiaries of their IRAs or other retirement accounts, the children of the first marriage of the account holder. So that would be a contract that would be entered into between the surviving spouse and the IRA owner to say, you get this for your lifetime, but your designated beneficiary has to be the children of my first marriage. And it's an enforceable contract. I mean, like any contract, it can be breached, but it would be enforced by the beneficiaries who were being shortchanged, the children of the first marriage. And so that is one thing to do. Sometimes if there are multiple IRAs, then some are left to the surviving spouse and some are left to the kids of the first marriage. Sometimes IRAs can be split off into subsections to do that, just moving some money from one custodian to another custodian and doing new designated beneficiaries. There's a lot of options around what we call contract assets, but I would say the key thing is to make sure those beneficiary designations are filled out, that they're updated, and that they're consistent with your overall retirement plan. Next slide, please. So we have a little case study to kind of cover all the ground we've just visited, but with some specific facts in mind. And this is an amalgam of many different clients. There's no one client I've worked with that fits this exact pattern, but these are just themes you see over and over again. So James and Judy Smith have been married 25 years. James is 12 years older than Judy. They have one child, Sam, who's 23 years old. James was married previously and has two children, Alex and Ann, who are 29 and 32 years old, respectively. Judy is on cordial terms with Alex and Ann, but feels that they will benefit sufficiently from their mother's estate and that James's estate should be primarily for their son, Sam. James and Judy come to an estate planner to establish irrevocable family trusts and other estate planning documents that take into account their blended family. Next slide, please. So the estate planner recommends that at the first death, two trusts arise: an irrevocable trust, often called a decedent's trust, a bypass trust, or a credit shelter trust. Those three names are used interchangeably, but that's that irrevocable trust we spoke about. And then the second trust would be a survivor's trust. The decedent's trust will be funded with separate property of the first spouse to die, possibly James, he's older, and James's half of the community property. The beneficiaries of the decedent's trust will be the surviving spouse, Judy, for her lifetime, followed by the three children in equal shares. The surviving spouse, Judy, cannot change the beneficiaries of the decedent's trust. She can change the beneficiaries of the survivor's trust. Next slide. So the survivor's trust will contain Judy's separate property and Judy's share of the community property. It will remain revocable for Judy's lifetime. In this case, Judy could make Sam the sole beneficiary of the survivor's trust, but she could not change the fact that the decedent's trust is split equally among the three children. Judy would receive income from both the decedent's and the survivor's trust and any principal of the survivor's trust. Now, the principal of the decedent's trust could be used for her health, education, maintenance, and support. So again, to recap, she could do whatever she wants with the survivor's trust. She can give it all to Sam. She can spend it down during her lifetime. But that irrevocable decedent's trust cannot be spent down by her during her lifetime unless her health, education, maintenance, and support needs exhaust the trust property. And she cannot change the beneficiaries of the decedent's trust from the equal division between or among Sam and the kids of James's first marriage, if James is the first spouse to die. Next slide. James and Judy designated each other as primary beneficiaries of their respective IRA accounts. The three children are the secondary contingent beneficiaries in equal thirds. James and Judy entered into agreement so that each would designate the children in equal thirds as primary beneficiaries of any spousal IRAs created on the death of the other. And again, this is a contract that could be breached. They could change the beneficiary designation. Judy could change hers so it's just Sam, but the kids of the first marriage could contest that, and there would be, unfortunately, litigation of some sort or lawyers' letters and a battle over the breach of the promise that was made in writing. Next slide. So the estate plan designed for James and Judy's blended family will remove any conflict among Judy, the second spouse, and Alex and Ann, the children of the first marriage, if James is the first to die. Similarly, if Judy is the first to die, she will know that James will not be able to give everything to the children of his prior marriage. Even the retirement benefits are protected from an equal disposition. And the end result is an even-handed treatment of children from both marriages. So that's one way that estate planning can help to smooth over the conflicts that could arise if, for instance, there was no irrevocable trust at James's death and everything went to Judy's survivor's trust. Judy could leave everything to Sam. Alex and Ann could be cut out. And the same thing could happen with the retirement accounts and the life insurance benefits if there isn't that prior contractual agreement to treat the children equally. And all of this, as you can imagine, it's not an off-the-shelf solution. It's a custom tailored solution for a specific family. It requires it respects the dynamics of the family. It requires there be some cooperation. And it is something that is going to be different for each family's dynamics and each family's makeup and each family's finances and needs. Next slide. That brings me to the end of my presentation, and I think if we have time for questions, then now would be the time for any questions that have come up.
Well, thank you, Christine. We so appreciate you sharing this information. There are a few questions that I have as well as a few that are in the chat. So let me kind of ping pong between some of those different questions that have come up. When would someone need a prenup? Can you go over that again?
Sure. A prenup is desirable very often when there is a significant wealth imbalance between two people who are going to get married, because they're very often the spouse who doesn't have the greater finances is living in a fashion and a style that they could not support on their own. So there's a desire for the spouse with more assets to provide for the other spouse through payments after their death, or some sort of arrangement to allow them to live in the home that they share. And so I would say unequal property holdings and wealth holdings would be the primary driver of a prenup. But another one is whenever there is separate property on one or both sides of the marriage and a desire to keep it separate after the marriage.
Okay.
And that can come up during a marriage with a postnup, like I said, especially if one spouse inherits a significant amount of money and desires to keep it separate.
And then you mentioned a postnup too. So when would be the best time to have something like that? And especially talk a little bit more about the debt scenario. I think that's quite interesting.
Sure. Well, I mean, a postnup, I had clients who had very separate arrangements for their property. They each own separate property. They own some community property, but they each own separate property. They'd had a prenup that wasn't done by an attorney. And so before doing their estate plan, I said, let's get an attorney's postnup to document what the prenup would have documented, so we have a clear playing field in terms of what is community, what is separate, and who gets what at death and incapacity. And that's what we did. So that was just a case where there was separate property on both sides and sort of a failed prenup. So that was one postnup. Now with debt, debt that is if you have a separate property student loan and get married in a community property state, and you both put your salaries into a single family checking account and you're drawing on it to pay off that separate property student loan, you're using community funds to pay a separate debt. And the community, there's the other party in the marriage has a community property basically reimbursement right if there's a divorce. Now, a lot of times nowadays, both couples have student loans and they're both using the community to pay the student loans. So it's sort of 6 of one, half dozen of the other, unless one person's loan is like a medical student loan and the other person has like a paralegal certificate loan. And there's a real unequal amount of community property that's being used to pay those loans off. So I would say, especially if just one of the parties to the relationship has a significant separate property debt that they're paying off with community funds, that might be a reason to have a prenup or a postnup.
Great, thank you. Let's talk a little bit about the case study you provided. Is there any legal recourse if one of the children in your scenario is unhappy?
Well, if we imagine that they didn't do they did some estate planning, but they decided not to have that irrevocable trust arise to protect the interests of the children of the first marriage, then and everything went to survivor spouse, and Judy made it quite clear she was leaving everything to Sam, then the kids of the first marriage would not have a lot of recourse. The main ways to attack someone over not getting what you wanted in an estate plan are that the person who would have left you the property was either incapacitated when they made the estate plan they made that left you out, or that they were unduly influenced by someone to leave you out. So they would have to show that that their dad lacked capacity when he agreed to the estate plan, leaving everything to Judy, or that Judy unduly influenced him. And that's very difficult to show. Very, very factually specific, fact-dependent showing. And it would be, if he had a clear, strong signature and there were multiple meetings with the estate planners and he was very clear that he wanted to do this and leave everything to his second spouse, then it would be almost impossible to overturn that arrangement.
Yeah, understood. So again, going to your case study and talking about the beneficiary designations, you mentioned that it was a mutual agreement that James and Judy would have between each other of who they would designate for their IRAs or whatever their beneficiary life insurance plans, that sort of
Mm-hmm.
thing. What is this mutual agreement? Because you mentioned that it could be broken. It sounds like there needs to be a lot of trust involved, but is this done by an attorney?
Sure, the estate planning attorney could draft it up as part of the overall estate plan. They could supervise preparation of the beneficiary designations for the IRAs and the retirement accounts, and they could draft up this agreement referencing the specific accounts that are subject to the agreement. Yeah, it is a short, brief, succinct contract that they both have capacity to make at the time they make it, and could be breached, but could be enforced as well, just like any contract.
Yeah. Here's an interesting question. What if a child from your spouse's first marriage is special needs? What is the
Sure.
best way to leave them money for their care?
Well, they need a special needs trust, because if they're on what are called needs tested public benefits like SSI or Medi-Cal, they can not have wealth of any sort. They have very strict dollar limits on the amount of money they can have in their name over the course of any given month. And so you need a special needs trust for them. So if going back to our example, if Sam were a special needs child, then Sam's share would not go to Sam outright. It would go to Sam's special needs trust, which is a separate trust set up by an attorney with some special needs expertise, and protects their entitlement to public benefits.
Okay. If there is no spouse, only adult children and minor grandchildren, can a trust be formed to give property and savings slash stocks unevenly to children and only one grandchild?
You know, so there's no surviving spouse. There's a settlor, or a trustor, we call them, the person who's going to set the trust up, and then there's their adult children and some grandchildren, and they want to allocate their trust property unequally among the children and grandchildren. You can do that, but boy, you better have a good reason, and it's best to put it in writing and communicate it transparently to the children in advance, so they don't get, shell shock after you're gone. I mean, if you say, look, your brother's a brain surgeon, you work for a nonprofit, I'm giving you more because of your lifestyle, and your brother has said he doesn't need it, then that's or your brother has special needs and needs money and trust to survive a long life with severe disabilities, so they're getting more and you're not, and this is why. So, having these clear, transparent, and communicated motives for treating children unequally is really important.
Yeah.
Um,
I was
and
going to mention, we did do a lunch and learn. If you go back into all the museum's YouTube channels and the various lunch and learns we've done, we had one called Having the Conversation. And just as you mentioned, it's super important to
mhm,
have that dialogue and make sure that everyone knows your intentions.
mhm. Yeah, there are good reasons for people for the kids and the grandkids to not get money allocated equally, but they had better be clear, they had better be communicated, and there's hopefully love in everyone's heart when it happens. Sometimes there is family estrangement. Sometimes that is a reason for people to not receive anything in an estate plan. But again, just a clear communication that it's not out of lack of love, it's just out of circumstance, is the better approach than just sort of dropping the mic in an estate planning fashion and letting people deal with the aftermath.
And all the more reason to meet with an attorney and have a formal trust done, because if you have specific plans like that, if you don't have a trust, the state is not going to read your mind, and they're
Sure.
going to give
Well,
everything
the
equally.
probate code will give everything equally. The probate code is your estate plan if you don't have your own. If you don't have a will or a trust, or ideally a will and a trust, then the probate code is going to dictate exactly what happens, and it's going to happen publicly, and it's going to happen at great expense.
Yeah.
So that's why we do what we do, because California is one of those states where probate is expensive and very time consuming and slow. Other states, it's swift. It's never private, but in other states, it's swift and everybody does it. But California is not one of those states.
No. So as you know, the museum has a free will tool planner on our website. Can trusts like we're discussing now be done on that free will tool maker?
If it's a will toolmaker, then no. Trusts, irrevocable trusts and trusts with an irrevocable trust at the first death would probably be outside their specs. If it's just allowing someone to create a basic will, then this goes beyond the parameters of just a basic will. This we're talking about a revocable trust that has sub-trusts that arise at the first death, one of which is irrevocable, and I would not recommend you do that on your own any more than I would recommend that I, as an attorney, try to fix my car when the engine light is on. It's just
Yeah.
something for specialized technicians.
Right. And for someone who has a simple estate plan and not a lot of assets by any means, the museum's free will tool maker is appropriate. But in a case like this, for sure, meeting with an attorney is going to be your best bet to make sure everything is expedited as you wish.
Oh, sure,
Yeah.
sure, yeah.
Here's another one. Any special considerations when the new partners are not married?
Wow. Well, yeah, they probably need separate estate plans. There's not going to be any marital deduction planning. Marital deduction is one of the biggest, tax deductions in the estate planning arena. They're going to need to have separate estate plans. Maybe they each have bequests for the other in their estate plan. But there won't be you need to have a marriage in order to do marital deduction planning.
So what if in the case of James and Judy, they weren't, well, I guess they are married, but I'm trying to think of like, so James has had this other marriage and
Sure.
now he and Judy are together. They may have a kid, but they
Right,
never got married.
right,
But
right.
common law marriage.
I've seen this with clients. They have separate estate plans, and there may be, for instance, provisions that Judy can stay in the house as long as Sam is a minor, but maybe not after then. There may be a bequest for Judy. Usually it's just not as usually it's not as generous as the provisions for a surviving spouse, because you don't have the bond of marriage, and it's one of those things where if you provide for a non-married partner in your irrevocable trust, you have to really you have to babysit that relationship. And if it changes and ends, you've got to go back to your estate planner and say, hey, this person isn't in my life anymore, and I'm not leaving that bequest to them anymore, and I'm leaving that bequest to someone else instead. And it just like when you get divorced, you've got to go in and change the joint trust you have with the spouse that you're no longer married to.
Yeah. So we've gotten a question. So about how much does this cost to meet with an attorney and get the trust together and all that?
That's a really good question. And it ranges. You got to realize when you do this, you're getting a revocable trust, two pour over wills, I'm assuming a couple comes in, 2 durable powers of attorney, 2 advanced healthcare directives. It's usually a certification of trust, a general assignment of assets. We put the house in trust. There's forms that go along with that. There may be other documents assigning businesses to interest to the trust. You get about a dozen legal documents, all of which are individually crafted for your factual situation. And I would say that the fee for that ranges from about $3,500 to $4,000 at the lower end to more like $5,000 or $6,000 at the upper end, where there's multiple pieces of property or maybe business interests that need to be transferred to the trust. And in really complicated factual settings, I once had a client that had rental properties and separate checking and savings accounts for all the rental properties, and there were 30 bank accounts that needed to be tracked across 3 different trust schedules. It can get up into even higher ranges for fees.
Yeah.
But your more entry level is down more towards 3,500 or $4,000.
And as you know, we do a workshop in November, which you can see on the screen there, November 15th. It's an estate planning essentials workshop, and your colleague at Mullen and Henzell, Brett Piersma,
Oh
does a
yeah,
great job of showing if you don't have any sort of plan and your estate
probate
ends
fees.
up going through probate, what that ends up costing you and your
Yeah,
family.
tens of
Um,
thousands of dollars.
Tens of thousands of dollars.
Tens
So
of
when you
thousands
think
of
of,
dollars. Yeah,
yeah, meeting with an estate attorney, getting a
yeah.
dozen plus different legal documents at the
For
tune of, 3,500 to 5,000 or
yeah.
whatever it ends up being, it's well worth the money to put your plan in on paper and in advance so
Yeah.
that you don't go through probate.
Yeah, because probate fees are going to be $30,000 to $50,000, even for a modest estate where you just have a home and a few life insurance, a few retirement accounts. I mean, it just goes right out. And it just takes away from whatever you're leaving to your family. So this you have to think of this as a gift to yourself and as a gift to your loved ones because it's intentional, it's deliberate, it's meaningful, and it's custom. And just like any other custom tailored thing you buy, whether it's a suit or a custom detail on your car, it takes time, it takes expertise, and it's for the long term.
Yeah, thank you. I have had a couple questions about finding some different things on the museum's website. Just a quick note, like all the Lunch and Learn webinars I've mentioned, other information about the free will tool planner. All of that is on the legacy giving pages of the museum's website. So if you type in under search legacy giving, you should be connected to all that. And there's various bubbles at the top that you can see language for a bequest if you want to include the museum in your estate plan and what have you. So thank you again,
Oh,
Christine.
my
We
pleasure.
really appreciate your time and expertise. On the screen, you see our contact information if you should have any additional questions or would like to talk about your specific needs. And again, thank you for keeping the museum in mind as you plan confidently and proactively. Also, as you'll see, we do have another webinar coming up for our 2026 series, and that's going to be in September. That is on September 8th from noon to 1, and more information will be coming out closer to that date, but it's going to be generally around how to age in place and how to prepare to age in place. So that should be a very interesting topic, especially as we look to help our parents and or as we consider how much other retirement communities cost and what have you. And if you don't already have an estate plan, please consider joining us at the Estate Planning Essentials Workshop on Sunday, November 15th from 2 to 4. Making sure that your wishes are honored and your family is protected and your assets are managed according to your wishes is super important. And so we're here to help you in that. Again, thank you, Christine. Thank you
You're
to the
welcome.
museum's Plan Giving Advisory Council for helping to coordinate the presentation. And thank you to all of you for attending. Have a fantastic day, and we look forward to seeing you in September.
Take care.
Thanks.
Bye-bye.
Bye.